Okay, consent searches, part 10 of chapter 3, arrest, search, and seizure. So-called consent searches are frequently relied upon by police as a means of investigating suspected criminal conduct. Sometimes probable cause is present, but the police feel either that they do not have time to get a warrant or that they would simply like to avoid that time-consuming process. But more often, an effort is made to obtain consent where probable cause is lacking and no warrant could be obtained. The exact meaning of consent in this context is the question explored in Schneckloth versus Bustamonte is thus a matter of some importance. In Schneckloth, by way of showing that the protections of the Fourth Amendment are of a wholly different order than various other constitutional rights, the court ordered that a person's privacy may sometimes be lawfully invaded by virtue of consent obtained by police from a third party. This raises the question of whether, at least in some circumstances, that third-party consent can even trump a refusal to consent by a co-occupant of the place to be searched, considered in Georgia versus Randolph. Schneckloth versus Bustamonte in 1973. Justice Stewart delivered the opinion of the court. While on routine patrol at 2:40 in the morning, a police officer stopped an automobile when he observed that one headlight and its license plate were burned out. 6 men were in the vehicle. When the driver could not produce a driver's license, the officer asked if any of the other 5 had evidence of his identification. Only the officer asked if any of the other 5... only Alcala produced a license, and he explained that the car was his brother's. The officer asked Alcala if he could search the car. And Alcala replied, "Sure, go ahead," and actually helped in the search of the car. By opening the trunk and glove compartment, 3 checks that had previously been stolen from a car wash were found wadded up under the left rear seat. The checks in question were admitted in evidence at Bustamonte's trial. He was convicted. The California Court of Appeal affirmed the conviction. For what? He was convicted of... Okay, don't know. Thereafter, the respondent sought a writ of habeas corpus in federal district court. It was denied. On appeal, the Court of Appeals for the Ninth Circuit set aside the district court's order. The precise question in this case is, what must the state prove to demonstrate that a consent was voluntarily given? The most extensive judicial exposition of the meaning of voluntariness has been developed in those cases in which the court has had to determine the voluntariness of a defendant's confession for purposes of the 14th Amendment. It is to that body of case law that we turn for the initial guidance on the meaning of voluntariness in the present context. The significant fact about all of these decisions is that none of them turned on the presence or absence of a single controlling criterion. Each reflected a careful scrutiny of all surrounding circumstances. So, surrounding circumstances, it's case specific. So, to answer voluntariness, we're going to go to case law. In none of them did the court rule that the due process clause required the prosecution to prove as part of an initial burden that the defendant knew he had the right to refuse to answer the questions that were put. While the state of the accused's mind and the failure of the police to advise the accused of his rights were certainly factors in the evaluation to be evaluated in assessing the voluntariness of the accused's responses, they were not in and of themselves determinative. Similar considerations lead us to agree with the courts of California that the question whether a consent to a search was in fact voluntary or was the product of duress or coercion, express or implied, is a question of fact to be determined from the totality of the circumstances, which is another way of saying what we just said. Very certain. While knowledge of the right to refuse consent is one factor to be taken into account, the government need not establish such knowledge as in the sine qua non of an effective consent. That's interesting. Use of sine qua non. I'm probably going to read that again because I can't understand how they're using it. I mean, except I guess to figure out something you don't know, right? But it came out tort law. So while knowledge of the right to refuse consent is one factor to be taken into account, the government need not establish such knowledge as the sine qua non of an effective consent. As with police questioning, two competing concerns must be accommodated in determining the meaning of a voluntary consent, the legitimate need for such searches, and the equally important requirement of assuring the absence of coercion. In situations where the police have some evidence of illicit activity but lack of probable cause to arrest or search, a search authorized by valid consent may be the only means of obtaining important and reliable evidence. In the present case, for example, while the police reasoned to stop the car for traffic violations, the state does not contend that there was probable cause to search the vehicle or that the search was incident to a valid arrest of any of the occupants, yet the search yielded tangible evidence that served as a basis of prosecution and provided some assurance that others wholly innocent of the crime were not mistakenly brought to trial. Okay, in the other case, in the case of the stolen checks, unrelated, that they wouldn't falsely prosecute someone else. In those cases where the probable cause to arrest or search, but where the police lack a warrant, a consent search may still be valuable if the search is conducted and proves fruitless, that in itself may convince the police that an arrest with its possible stigma and embarrassment is unnecessary, or that a far more extensive search pursuant to a warrant is not justified. In short, a search pursuant to consent may result in considerably less convenience for the subject of the search, and properly conducted is a constitutionally permissible and wholly legitimate aspect in effective police activity. But the 4th and 14th Amendment require that a consent not be coerced by explicit or implicit means, by applied threat or covert force, or no matter how subtly the coercion were applied, and the resulting consent would be no more than a pretext for unjustified police intrusion against the 4th Amendment as directed. So this is kind of the principle. The problem of reconciling the recognized legitimacy of consent searches with the requirement that they be free from any aspect of official coercion cannot be resolved by an infallible touchstone. To approve such searches without the most careful scrutiny would sanction the possibility of official coercion. To place artificial restrictions upon the searches would jeopardize their basic validity, just as was true with confession. The requirement of voluntary consent reflects a fair accommodation of the constitutional requirements involved. In examining all the surrounding circumstances to determine if the fact of consent to search was coerced, account may be taken of subtly coercive police questions as well as the possibly vulnerable subjective state of the person who consents. Those searches that are the product of police coercion can thus be filtered out without undermining the continuing validity of consent searches. In sum, there is no reason for us to depart in the area of consent searches from the traditional definition of voluntariness. Which I guess is what I said above here. 4th and 14th require that a consent not be coerced by explicit or implicit means, by implied threat or covert force, for no matter how subtly coercion is applied, the resulting consent would be no more a pretext for the unjustified police intrusion against which the Fourth Amendment is directed. The approach of the Court of Appeals in the Ninth Circuit finds no support in any of our decisions that have attempted to define the meaning of voluntariness. Its ruling that the same must affirmatively prove that the subject of the search knew that he had a right to refuse consent would, in practice, create serious doubt whether consent searches will continue to be conducted. There might be rare, so to make such a ruling could be disastrous. There might be rare cases where it could be proved from the record that a person in fact affirmatively knew of his right to refuse, such as the case where he announced to the police that if he didn't sign the consent form, the police are going to get a search warrant, or a case where prior experience and training a person had clearly and convincingly demonstrated such knowledge. But more commonly, where there was no evidence of any coercion, explicit or implicit, the prosecution would nevertheless be unable to demonstrate that the subject of the search, in fact, had known of his right to refuse consent. The very object of the inquiry, the nature of the person's subjective understanding, underlines the difficulty of the prosecution's burden under the rule applied by the Court of Appeals in this case. Any defendant who was the subject of a search authorized solely by his consent could effectively frustrate the introduction into evidence of the fruits that the search by simply failing to testify that he in fact knew he could refuse consent. And the near impossibility of meeting this prosecutorial burden suggests why the court has never accepted any such litmus paper test of voluntariness. So, one alternative that would go far towards proving the subject of a search did know he had a right to refuse consent would be to advise him of the right before eliciting his consent. That, however, is a suggestion that has almost universally repudiated by both federal and state courts, and we think rightly so, for it would be thoroughly impracticable to impose a normal consent search. The detailed requirements of effective warning. Consent searches are part of the standard investigatory techniques of law enforcement agencies. They normally occur on the highway or in a person's home or office under informal and unstructured conditions. The circumstances that prompt the initial request to search may develop quickly or be a logical extension of investigative police questioning. The police may seek to investigate further suspicious circumstances or to follow up leads developed in questioning persons at the scene of the crime. These, by counts, These situations are a far cry from the structured atmosphere of a trial where, assisted by counsel if he chooses, the defendant is informed of his trial rights. And while surely a closer question, these situations are still immeasurably far removed from the custodial interrogation where Miranda versus Arizona, we found that the Constitution required certain now familiar warnings as a prerequisite to police interrogation. It is said, however, that a consent is a waiver of a person's rights under the 4th and 14th Amendments. The argument is that by allowing the police to conduct a search, a person waives whatever right he had to prevent the police from searching. It is argued that under the doctrine of Johnson versus Zurburst, to establish such a waiver, the state must demonstrate an intentional relinquishment or abandonment of a known right or privilege. Almost without exception, the requirement of a knowing and intelligent waiver has been applied only to those rights which the Constitution guarantees to a criminal defendant in order to preserve a fair trial. Hence, and hardly surprisingly, in view of the facts of Johnson itself, the standard of a knowing and intelligent waiver has most often been applied in the test of the validity of the waiver of counsel, either at trial or upon a guilty plea. And the court has also applied the Johnson criteria to assess effectiveness of a waiver of other trial rights, such as the right to confrontation, a jury trial, a speedy trial, the right to be free from choice being placed in jeopardy, and guilty pleas have often been scrutinized to determine whether the accused knew and understood all the rights to which he would be entitled at trial and that he had intentionally chosen to forego them. And the court has evaluated the knowing and intelligent nature of the waiver of trial rights in trial-type situations, such as the waiver of the privilege against compulsory self-incrimination before an administrative agency or a congressional committee, or the waiver of counsel in judicial proceedings. The guarantees afforded a criminal defendant at trial also protect him at certain stages before the actual trial, and any alleged waiver must meet the strict standard of an intentional relinquishment of a known right. But the trial guarantees that have been applied to a pretrial stage of the criminal process are similarly designed to protect the fairness of the trial itself. The standards of Johnson were, therefore, found to be a necessary prerequisite to a finding of valid waiver. A strict standard of waiver has been applied to those rights guaranteed a criminal defendant to ensure that he will be afforded the greatest possible opportunity to utilize every facet of the constitutional model of a fair criminal trial. Any trial conducted in derogation of that model leaves open the possibility that the trial reach an unfair result, and precisely because all the protections specified in the Constitution are not provided. A prime example is the right to counsel. For without that right, a wholly innocent accused faces the real and substantial danger that simply because of his lack of legal expertise he may be convicted. The protections of the Fourth Amendment are of a wholly different order and have nothing whatsoever to do with promoting the fair ascertainment of truth at a criminal trial. Rather, as Justice Frank Furter's opinion for the court put it in Wolf v. Colorado, the Fourth Amendment protects the security of one's privacy against arbitrary intrusion by the police. Nor can it even be said that a search as opposed to an eventual trial is somehow unfair if a person consents to a search. While the Fourth and 14th Amendments limit the circumstances under which the police can conduct a search, there is nothing constitutionally suspect in a person voluntarily allowing a search. The actual conduct of the search may be precisely the same if the police had obtained a warrant, and unlike those constitutional guarantees that protect a defendant at trial, cannot be said every reasonable presumption ought to be indulged against voluntary relinquishment. We have only recently stated it is no part of the policy underlying the Fourth and 14th Amendments to discourage citizens from aiding to the utmost of their ability in the apprehension of criminals. Rather, the community has a real interest in encouraging consent, for the resulting search may yield necessary evidence for the solution and prosecution of crime, evidence that may ensure that a wholly innocent person is not wrongly charged with a criminal offense. Those cases that have dealt with the application of the Johnson v. Zerbis rule make clear that it would be next to impossible to apply the consent search, the standard of an intentional relinquishment or abandonment of a known right or privilege. To be true to Johnson and its progeny, there must be an examination into the knowing and understanding nature of the waiver, an examination that was designed for the trial judge in a structured atmosphere of a courtroom. It would be unrealistic to expect that in an informal, unstructured context of the consent search, a policeman, upon pain of tainting the evidence obtained, could make the detailed type of examination demanded by Johnson. And if for this reason a diluted form of waiver were found acceptable, that would itself be ample recognition of the fact there is no universal standard that must be applied in every situation where a person forgoes a constitutional right. Similarly, a waiver approach to consent searches would be thoroughly inconsistent with our decisions that have approved third-party consents. It is inconceivable that the Constitution could countenance the waiver of a defendant's right to counsel by a third party, or that a waiver could be found because a trial judge reasonably thought, though mistakenly believed, a defendant had waived his right to plead not guilty. Much of what has already been said disposes of the argument that the court's decision in the Miranda case requires the conclusion that knowledge of a right to refuse is an indispensable element of a valid consent. The considerations that inform the court's holding in Miranda are simply inapplicable in the present case. In Miranda, the court found that the techniques of police questioning and the nature of custodial surroundings produce an inherently coercive situation. The court concluded that unless adequate protective devices are employed to dispel the compulsion inherent in custodial surroundings, no statement obtained from the defendant can truly be the product of his free choice. And at another point, the court noted that without proper safeguards, the process of in-custody interrogation of a person suspected or accused of crime contains inherently compelling pressures which work to undermine the individual's will to resist and compel him to speak where he would not otherwise do so freely. In this case, there is no evidence of any inherently coercive tactics, either from the nature of the police questioning or the environment in which it took place. Indeed, since consent searches will normally occur on the person's own familiar territory, the specter of incommunicado police interrogation in some remote station house is simply an opposite. There is no reason to believe, under circumstances such as are present here, that the response to a policeman's question is presumptively coerced. And there is therefore no reason to reject the traditional test for determining the voluntariness of a person's response. Miranda, of course, did not reach investigative questioning of a person not in custody, which is most directly analogous to the situation of a consent search, and it assuredly did not indicate that such questioning ought to be deemed inherently coercive. It is also argued that the failure to require the government to establish knowledge of a prerequisite to a valid consent will relegate the Fourth Amendment to a special province of the sophisticated, the knowledgeable, and the privileged. We cannot agree. The traditional definition of voluntariness we accept today has always been taken into account evidence of minimal schooling, low intelligence, and the lack of any effective warnings to a person of his rights. The voluntariness of any statement taken under those conditions has been carefully scrutinized to determine whether it was in fact voluntarily given. Our decision today is a narrow one. We hold only that when the subject of a search is not in custody and the state attempts to justify a search on the basis of its consent, the 4th and 14th Amendments require that it demonstrate that the consent was in fact voluntarily given and not the result of duress, coercion, express or implied. Voluntariness is a question of fact to be determined from all circumstances. While the subject knowledge of a right to refuse is a factor to be taken into account, the prosecution is not required to demonstrate such knowledge as a prerequisite to establishing consent. So that's the holding. And dissenting is Justice Marshall. The footnotes talk about Florida versus Gimeno. Neither the suspect's intent nor the officer's perception thereof, but rather that of objective reasonableness. A typical person would have understood the exchange is Gimeno for you from 1991. Okay, so there's only one dissenting opinion here. The court assumes that the issue in this case is what are the standards by which the courts are to determine the consent is voluntarily given. It then imports into the law the search and seizure standards developed to decide entirely different questions about coerced confessions. The Fifth Amendment in terms provides that no person shall be compelled in any criminal case to be a witness against himself, nor is the interest protected by the Due Process Clause of the 14th Amendment any different. The inquiry in the case where a confession is challenged as having been elicited in an unconstitutional manner is therefore whether the behavior of the police amounted to compulsion of the defendant. In contrast, this case deals not with coercion but with consent. It's a subtly different concept to which different standards have been applied in the past. Freedom from coercion is a substantive right guaranteed by the 5th and 14th Amendments. Consent, however, is a mechanism by which substantive requirements otherwise applicable are avoided. Thus, consent searches are permitted not because such an exception to the requirements of probable cause and warrant is essential to proper law enforcement, but because we permit our citizens to choose whether or not they wish to exercise their constitutional rights. Our prior decisions simply do not support the view that a meaningful choice has been made solely because no coercion was brought to bear on the subject. If consent to search means that a person has chosen to forego his right to exclude the police from the place they seek to search, it follows that his consent cannot be considered a meaningful choice unless he knew that he could, in fact, exclude the police. I would therefore hold at a minimum that the prosecution may not report on a purported consent to search in the subject of the search did not know that he could refuse to give consent. Where the police claim authority to search yet in fact lack such authority, the subject does not know that he may permissibly refuse them entry, and it is this lack of knowledge that invalidates the consent. The burden on the prosecutor would disappear, of course, if the police at the time they requested consent to search also told the subject that he had no right to refuse consent, and thus his decision to refuse would be respected. The court's assertions to the contrary notwithstanding, there is nothing impractical about this method of satisfying the prosecution's burden of proof. The court contends that if an officer paused to inform the suspect of his rights, the informality of the exchange would be destroyed. I doubt that a simple statement by an officer of the individual's right to refuse consent would do much to alter the informality of the exchange, except to alert the subject to a fact that he surely is entitled to know. It is not without significance that for many years the agents of the federal FBI have routinely informed suspects of their right to refuse consent when they request consent to search. The reported cases in which the police have informed the subject of their right to refuse consent show that the information can be given without disrupting the casual flow of events. What evidence there is then rather strongly suggests that nothing disastrous would happen if the police, before requesting consent, informed the subject that he had a right to refuse consent and that his refusal would be respected. So, making comparisons to FBIs have routinely done this. Interesting. Last paragraph, I must conclude in the dissent, that is, with some reluctance that when the court speaks of practicality, what it really is talking of is the continued ability of police to capitalize on ignorance of citizens so as to accomplish by subterfuge what they could not achieve by relying only on the knowing relinquishment of constitutional rights. Of course, it would be practical for the police to ignore the commands of the Fourth Amendment, but if by practicality we meant that more criminals will be apprehended, even though the constitutional rights of innocent people also go by the boards. But such a practical advantage is achieved only at the cost of permitting the police to disregard the limitations that the Constitution places on their behavior, a cost that a constitutional democracy cannot long absorb.